SJC-11220, Commonwealth versus Robert Vacher.
All right, let's proceed. Good morning.
Good morning, Mr. Chief Justice, and may it please the Court. Defendant Robert Vacher was prosecuted and convicted of first-degree murder and related charges arising out of the death of Jordan Mendez on December 15, 2008. The bulk of the inculpatory evidence at trial came from 5 immunized witnesses and from the fruits of a stop of Vacher's automobile on December 18, 2008, including his custodial statements and the fruits of a subsequent search of that automobile. And it's those 2 sources of evidence that provide the basis for 2 of his principal arguments on appeal. Let me turn first to the issue relating to the stop of the car and the fruits of that stop. When Vacher's car was stopped on that date, and ultimately the motion judge found that, in fact, he was arrested on that date and that his subsequent interrogation was custodial. So it needs to be analyzed, I think, properly under the rubric of whether or not there was probable cause to arrest. And while the police have been investigating for several days, by far the most significant piece of evidence they had against Vacher when they stopped his car on the night of the 18th was the statement of one of 2 juveniles who were also implicated in this crime and who had been interrogated earlier that day. Specifically, juvenile number 2, who had given a detailed account of the killing directly implicating Vacher. And a judge in the juvenile court, in the proceedings in that court, subsequently suppressed juvenile number 2's statement on grounds that there had been a violation of Edwards and that he had invoked his right to counsel, which had been ignored, that there had been a violation of Mavrodakis in that a lawyer came to the station to meet with him, and he was not informed that the lawyer was there and wanted to meet with him, and a violation of the procedures set forth by this court way back in 1983 in Commonwealth versus a juvenile, including the fact that an interested adult had to be present at all times when a juvenile under 14 was being interrogated.
But you're arguing that, oh, sorry.
Tried to top that one.
I'll let you folks work that out.
Justice Duffley?
And your claim is that notwithstanding the fact that at the time that the defendant was being arrested and on the basis of those statements, the subsequent conclusion that they were suppressed, should have been suppressed, meant that that initial PC was somehow tainted retrospectively.
I think that's right, Your Honor. I guess that there are 2 issues. One, if down the road a judge ultimately rules that the police engaged in illegal conduct or unconstitutional conduct, I would say yes, that certainly taints the initial. They're acting on that evidence. The second issue, which is I recognize is more problematic for me, is whether Vacher can rely upon the violation of juvenile number 2's rights to assert a violation himself under the target standing rubric.
Regarding to the first question, is good faith or bad faith an issue, a question at all?
Well, Your Honor, I think number 1 in Massachusetts, first, this was a warrantless. We're not talking about a search warrant. We're talking about a warrantless stop. Right. So I would say good faith is not at all an issue. If the police were, if the stop of Vacher's car was, in the words of Wong's son, and this court has, I think, recently parroted that language, I think if it was the exploitation of the primary illegality as opposed to a situation where there was enough of an attenuation to purge the taint, yes, I think that any as a fruit of that unlawful conduct, the subsequent conduct must be struck.
But to prevail on that, you would need for us to adopt some
some measure of target standing.
Well, that's the second issue, Your Honor.
And I guess with
that's
regard to
correct.
that, I mean, let's assume that what occurred with regard to juvenile 2 was awful and intentional, would meet all the other prongs. The problem I have with it is that there was no indication that they were targeting Vacher when they were interviewing the juvenile. No indication that they even knew about Vacher. So I understand the concept of target standing means you can't use a small fish to get a big fish, but that assumes you know that there is a big fish, and I don't know that you can show that they knew of the big fish when they were interviewing juvenile 2.
Well, let me respond a couple of ways, Your Honor. I guess there were two different doctrines that are implicated. I think one is target standing in that big fish, little fish sense. The other is more of a derivative standing sense, where irrespective of big fish, little fish, if the police unlawfully break into person A's house and rummage through it illegally and find something that relates to person B, even if they weren't focused on person B in the first place, person B can say, hey, based on the deterrent reason we have an exclusionary rule, I should be able to assert that the police should not be able to exploit that illegality to prosecute anybody, including me. That is a little different. As far as your question, Your Honor, about big fish, little fish, they absolutely knew about Vacher. They had been investigating Vacher from the beginning. They knew that Vacher and juvenile number 1, who was the person they really had most of the evidence against. Juvenile number 1 was the victim's half-brother, and it was really, and who he was in the drug business with, and most of the evidence they had was, putting aside the statement of juvenile 2, was really directed at juvenile 1. But Vacher had been seen with juvenile 1. Vacher and juvenile 1 had gone to the BMW store together, where they purchased a vehicle with cash. So they were absolutely focused on Vacher. And these two juveniles, I mean, they were both 13. Vacher was 20. So to suggest that Vacher was not the focus, I think, is absolutely incorrect. Based on all of the investigation they've been doing for 3 days, Vacher was clearly a focus of the investigation. I think I can't in good faith say he was the focus, because they were looking at all 3 of them. But as a practical matter, when you're talking about 2 13-year-olds who could only be prosecuted as juveniles, they can't even qualify under the Youthful Offender Act, and you're talking about an adult, under the legal system, Vacher is clearly the big fish. So I think it is fair to say that he was the one who, in these circumstances, can fit that appellation. But, yes, Your Honor.
Mr. Sultan, as I read the briefs, apparently there was a Benjamin Tubbs. Now, had Tubbs talked to the police before they stopped the car?
No, Your Honor. I don't believe, none of the immunized witnesses, there were 2 immunized witnesses who testified at trial that Vacher made inculpatory admissions to them. The police did not have that information from either of those people when the car was stopped. They didn't have anything, I submit, linking Vacher to this crime other than the statement that was elicited from juvenile number 2. If they had one of those statements, Your Honor, I would not be making this argument. They clearly would have had probable cause, but they did not have that. So with respect, and on the target standing issue, I know this court has suggested in the past, in old cases like Gallant and Manning and Scartamaglia, that, well, maybe we'd recognize target standing. It would have to be either coercion or distinctly egregious police conduct. And I would submit, number 1, that should be revisited. I know this court is revisiting it in another pending case, Santiago, where the court has asked for amicus briefs on this issue. But to me, if the issue really is whether, under the purposes of the exclusionary rule, which is to deter improper police conduct, the court should recognize that really the Wong-Sung rule should prevail. That if the subsequent seizure of evidence is an exploitation of a primary illegality, it should be excluded, and without trying to make some judgment call about how bad the police conduct really was. So that's my first position, and I guess my backup position would be that in this case, where we are talking about not some technical violation, but a violation of really a fundamental constitutional precepts, Edwards, Mavrodakis, and Commonwealth versus a juvenile, which are all long settled law. This was the interrogating officer was I think the chief of the juvenile department, or the juvenile section of the Barnstable Police Department. That was egregious under these circumstances, and if the court does want to continue to maintain some sort of a pecking order of how bad a constitutional violation has to be before we'll let somebody else utilize it, I would submit that this case qualifies.
Did the judge in the juvenile court say, though, that the juvenile 2 was that it was voluntary?
He did, Your Honor. So I can't argue, since I think his findings on that.
I mean, there were these violations, but
There was no coercion. I think that's right. I mean, that was a separate issue raised, a separate ground raised by the juveniles in their motion to suppress, and the motion judge did go out of his way to say, I don't find coercion. So to the extent this court has articulated sort of alternative bases for derivative or target standing, the coercion prong would not apply here, and I haven't argued that it does.
so you're saying that egregiousness stems from the fact that this is long-standing law, and that whether there was good faith or bad faith, whatever, in the conduct of the interrogation of juvenile 2 makes no difference. It's just the very fact that long-standing law was not complied with.
I would say that
That's what makes it egregious.
as opposed to a violation of the telephone statute that they didn't give him a call within whatever it is now, the safe harbor period. They gave him a call an hour later. He asked for a lawyer. They ignored it. That's settled federal and state constitutional law for 30 years. The lawyer came to the station, said, I want to meet with my client. They didn't let that happen. I think Mavrodakis is 2000, so that's basically virtually a decade. And Commonwealth versus a juvenile saying you have to have an interested parent there for the entire interrogation. This court decided that case in 1983. So I would say, yeah, that makes it egregious. Now, that's subjective to some extent. I don't like those kinds of line drawing. To me, it should be, if it's a constitutional violation, it's a constitutional violation. If the subsequent evidence is the exploitation of it, if it's not attenuated, the taint still exists, that should be enough. So I guess I differ with the attempt to sort of create a hierarchy of violations. But I do think in this case, if the court wants to maintain that hierarchy, this was bad enough to fall on the side of the line that warrants relief. Let me turn, if I can, to the second argument, which relates to the...
Just to be clear, that would go beyond target standing. That would be the abolition of standing.
No, Your Honor, it would be, I think it would be derivative standing. It would be, and I don't think this...
But then
and this
effectively,
court, I think,
everybody would be able to have standing to challenge any illegality.
I think that's right. I think that if there's a primary constitutional violation, that in order to deter the police from saying, well, we're going to go, we're going to unconstitutionally search this person's house, we don't care about this person, but maybe we'll find something on somebody else, I think that needs to be deterred. So that, and if the police know that whoever those somebody else's are going to be able to come into court and suppress whatever they seize from that illegal, unconstitutional search, that should deter the police from doing that. That's the purpose of the exclusionary rule, and I think that's how it should be applied. But I agree with Your Honor. It certainly would broaden its application.
And with regard to my question earlier, the BMW sale to Vacher was known before Juvenile 2? I thought Juvenile 2 mentioned it.
It was known, the police knew that Vacher had bought this car. It actually had been paid for mostly by Juvenile number 1. Juvenile number 1 had, according to the car salesman had been interviewed, and the car salesman had said that Juvenile number 1 had in fact done all of the negotiating and supplied most of the money, but it
Car
was...
sold for $11,000.
I think it was either 10 or 11,000 in cash, Your Honor. Yes, so that was known to the police. That's why they were looking for the BMW. He had bought the car. It was in Vacher's name. Obviously, it wasn't in the 13-year-old's name, and it had been registered. So that was known to them at the time of the stop.
Before Juvenile 2 was interviewed?
Yes, Your Honor.
Because it's not clear from the search warrant affidavit as to what the timing was.
I think that- I think
Investigation
if the
revealed.
court- if the court would look, I think it's in the statement of facts with respect to the evidence elicited during the suppression hearing. If I'm wrong, I'll correct it by a letter, but I'm quite sure they had that information before they interviewed Juvenile 2. With respect to the immunized testimony, if I can turn to that, in this case, you had 5 immunized witnesses, and who presented the bulk of the testimony against Vacher at trial. And I recognize that I am, to some extent, whistling into the wind with this argument, but to me, where we have an adversary system, and where this court has, in a number of cases, such as Durham, such as Ogden, basically said, look, this is supposed to be a level playing field. You know, in Durham, the court said reciprocal discovery is going to apply to the defense, just like we get discovery from the prosecution. It's supposed to be fair. In Ogden, this court said the Commonwealth has to use Rule 17 to get documents pre-trial, just like the defendant does. It's supposed to be a level playing field. If that is our system, if that's what it's predicated on, then how can there be a statute which says, and this court has said, the statute is not directed, is not concerned with the needs or not addressed to the interests of defendants. How can there be a statute like 233, Section 20C, which basically says one side, one party gets to immunize witnesses, and the other party, number one, can't do that, number two, can't even complain about it. This court has said in Smith 30 years ago that the defense doesn't even have standing to say anything about the fact that the prosecutor is immunizing his witness. This is a private procedure that's available to one party in an adversary system. They go in, they have their little hearing, they get their order, they have their immunized witness. In this case, 5 of them. The defense can't do any of that.
Well, what's the remedy you want on this point?
Well, I guess the first remedy that I've suggested is, frankly, that the statute is unconstitutional, that the statute is a violation of due process, that the statute distorts the truth-finding process, distorts the adversary system by basically giving one side an enormous advantage over the other, and that the legislature, while it can do a lot of things, can't do that. Now, you know, this has been around a long time. We've dealt with immunity and immunized witnesses, but I guess this is a good example of, you know, all of that power is on one side. How does that square with a level playing field and an adversary system, other than the fact that, well, that's the way we've always done it, so we're going to have to figure out that's the way we're going to keep
So
doing
you would
it.
like us to say that's unconstitutional?
I would, Your Honor, yes. That there has to be some provision for the defense to, if there's going to be immunized witnesses at trial, there's got to be some mechanism by which the defense can do the same.
Did the defendant ask to have a witness immunized?
Not in this case, Your Honor. And I recognize that I can't say, there was a Ninth Circuit case that I've cited, Straub, just a few years ago, where the court actually, where they held that in that case that they reversed because the prosecutor's witness was immunized, the defense's witness was not immunized. But the federal system obviously is different. The federal immunity statute is different. So I don't have that in this case. There was not a request to immunize somebody. But that doesn't change the fact that the statute says what it says. It's used the way that it's used.
I can't tell, though, whether you're saying that you want the right to have, you know, that the statute would only be constitutional if the defendant also had an equal right to immunize witnesses, or if you're talking about the defendant needing a right to complain about the Commonwealth immunizing witnesses. I can't tell which is the source of the problem.
Well, Your Honor, the source of my complaint primarily is that this is a mechanism to obtain evidence, critical evidence at a trial, that's available to only one of 2 parties in an adversary system. So that is the source of my objection. And in this case, it's not only that it was used, but it was used kind of in a piling on fashion. And if it's going to be used at all, this court, and if it's not going to be unconstitutional for this imbalance to remain in place, there should at least be some limit on how much it can be used.
This wasn't raised below, was it?
It was, Your Honor. The defense counsel, right before the last of the 5 immunized witnesses took the stand, went to sidebar, complained, called it structural error, They said it was a due process violation, so it was raised below. But for what it's worth, it was raised below. I think it's an important issue. I hope the court will take a look at it. With respect to the other issues raised in the brief, I'll rest on the brief unless the court has questions.
Thank you, Counsel.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Julia Haller on behalf of the Commonwealth. Just to address the immunized part of this, the structural error argument, while it was made below, the judge did say to the defense attorney, he did not object until the fifth and final witness, and then kind of went off on how he felt that this was structural error and it was not fair to the defendant, and the judge basically said, well, this is an 11th hour objection. You've known about this, that this was a possibility, and therefore you really are raising this kind of
Was the objection as to the fifth witness being called to testify, or was it as to all of them having been called to testify?
I think in the context of it, he starts with the fifth witness, but then he kind of brings all the others in, and he basically says, you've got 5 witnesses here, and this is just piling on, and
But did he ever say that I would be satisfied if the fifth witness didn't testify?
I think he doesn't want the fifth witness to testify. I think that's clear. But then he kind of senses that this is an objection he needs to make, and he kind of retroactively tries to make it to the other 4 witnesses as well at that point. And the judge says, well, this is late. You've known this. You didn't object to the other 4 witnesses. You can't raise it now.
And what did he say to that?
There was...
He
I don't
didn't say,
believe-
he didn't say
he
at
didn't
that point, I just want it as to the fifth witness?
No, he did not.
Okay.
No, he did not. And I just forgot what I was going to say. I apologize. If you look at the witnesses' testimony, each and every witness out of these 5 witnesses, one of them actually started to testify, and that was Benjamin Tubbs. And then the judge stopped them and said, so a couple of these witnesses were actually, not really out of an abundance of caution, were immunized, but the Commonwealth was ready for it to go with the immunized if it was needed. Benjamin Tubbs actually begins to testify, and when he starts talking about his own drug involvement, then the judge stops and says, we need to talk about this. I need to get you a lawyer. And Tubbs actually says, and he admits on cross-examination, that the statement, he's the main witness, he's the one who says, the defendant told me I killed somebody, I bodied somebody. That was when they were headed down Cape. And he testifies that he told the grand jury this as well, so his credibility, a lot of this was based upon the credibility argument the defendant certainly raised. You can't believe them, they're not credible, they've got these immunity deals. So the defendant made a lot of hay with this issue as well, and did what he could to just knock down the credibility of these witnesses. And at the time each of the immunized witnesses testified, the judge gave a very strong limiting instruction and said, and I refer to it in my brief, I don't have it quoted in my brief, but each time I have
A limiting
it.
instruction or a cautionary instruction?
Well, I mean, limiting, cautionary,
Well, they're different.
okay, I guess that you would call it more of a cautionary. He's not basically saying you can't use this evidence for something else, but he's basically saying but he does say, here's how you can evaluate this. And you have to look at it, you have to look at it very carefully. This means the Commonwealth, they're getting a benefit of something, and the last thing he says is, the Commonwealth's not saying these people are telling the truth. And that's the last thing he says. And then in his closing instructions, he does an even stronger one, which goes on for approximately 3 pages, on what the immunity means and how it affects how the jurors could use it to evaluate the credibility of these witnesses. And the Commonwealth obviously strenuously objects to, I'm moving on to the judicial immunity, sorry, I'm kind of on a roll here. With the judicial immunity, which the defendant is claiming, you can't have, I'm sorry, I don't want to go on to judicial immunity
With
yet,
regard to
sorry.
constitutionality, I gather there was no notice given to the AG of a challenge to the statute?
No, this was raised for the first time on appeal. This was never raised below by the attorneys. This was raised for the first time on appeal. And this court in Pixley has said, we'll consider it maybe in unique circumstances. And with all due respect to this court, you don't have anything before you the defendant never even asked. So there's no prejudice to this defendant. So there's none of these unique circumstances that you said you would consider. We have a statute which, for better or worse, as the defendant complains, allows the Commonwealth to do this process as the executive function to determine how they're going to prosecute people and how they're going to manage their own affairs in terms of this. And
essentially, I take it there that the government, when it invokes this statute, is giving up something in exchange.
well, we're giving up with the transactional immunity. We're giving up the right to prosecute. And the judge, the defense counsel brought that out in all of these witnesses. Well, you know, all of this drug stuff you've talked about, all of this stuff you talked about, the Commonwealth's just letting you get away with it, aren't they? And that was brought out to the jury. And they were well aware of you know, what the give and take was at this point. This just is...
But is this essentially a facial challenge to the statute?
Well, it actually isn't even raised as a facial challenge. It's more of a, you've got to give us the same opportunity to be able to have this same opportunity to get our witnesses immunized if we need them to be immunized. I don't read it as a facial challenge to the statute that I see in the defendant's brief. I could be wrong. But it's more of, give us the same opportunity to immunize our witnesses. Just blanket now say we have the same right. And this court, in none of its cases, going back even to Curtis, which was originally in 1983 and was revisited by this court in 1994, has given great deference to the Commonwealth as the executive to be able to, again, manage how it tries its cases and how it presents the evidence. And again, this case is not the opportunity that Your Honor should take because there is no evidence of prejudice to this defendant. It's just kind of in a vacuum here. We're not dealing with anything substantively involved in this case.
Well, except that he is saying that by having so many witnesses,
Right.
it has created structural error. It's a shift away from the idea of
But
maybe equal protection.
Structural error is, as this court has said, is used very rarely. It applies to things that show that the trial just could not have been fair to the defendant to the start. And this court has limited it to, you know, I think the closed courtroom is a good example of one, or...
Yeah, but here he's saying there's a gang of angels.
Well, that's not exactly, because what happens is the way the judge handles it, it was given, this was a jury question, and their immunity was right out there, was run up the flagpole. The Commonwealth wasn't trying to sugarcoat any of this. The Commonwealth has to go where the evidence leads it. If you say arbitrarily, like the defendant is asking you, 5 is too many, period, then what you're doing is you are potentially tying the Commonwealth's hands. The Commonwealth has to be able to go where the evidence in a case leads it. Now, in this case, it's not surprising when you have the death of a drug dealer by another drug dealer and 2 other people, or the defendant was a drug dealer as well, because they're greedy and they want his very lucrative pill business, where it's no question that the witnesses you have are not, I think it's the phrase used in the closing arguments, these aren't the people you want to have Sunday dinner with. I know you often hear that in a closing argument. You're going to be dealing with people who may have problems with drugs, who have their own problems. And I believe 3 of the 5 witnesses in this case, they were not immunized because of their involvement in this case. They were immunized because they bought pills from the defendant in Juvenile 1, they sold pills, they had their own drug involvement. They were not involved in the crime at all. In fact, none of the witnesses who were involved in the crime they were not involved in the crime. None of the 5 witnesses were directly involved in the crime. Only one, Benjamin Tubbs, and I think Susan Tubbs peripherally got rid of a knife. There might have been some, and it wasn't even linked to the case in any way, it's just that the defendant had possessed a knife and they got rid of it. And there was a knife admitted at trial that did have the defendant's DNA and the victim's DNA on it that was found in the automobile that they had used to, the Commonwealth's case, that they used this automobile to move the body from the house to the pit the night of the killing. So there really was nothing that, these 5 witnesses were not immunized for anything they did in this related to the murder. It was just, these are the circumstances. You've got people who were dealing drugs peripherally, and that's why they're being immunized. And the judge clearly addressed it with the jury, and it was a jury question as to the credibility of the witnesses.
If we can turn to target standing.
Sure.
2 questions. Mr. Sultan is usually right, but is he right with regard to the BMW sale being known before the arrest?
I believe it was known. It was known at that time. And I would differ with Mr. Sultan as to an interpretation of the facts. The salesman does testify that the defendant was very actively involved in the negotiating. He was an equal partner. It wasn't just Juvenile 1 who was the one who was negotiating it. And the defendant took out $2,500. And again, it was wrapped the same way as Juvenile 1's money. It was wrapped in the $1,000, which they refer to as stacks, the $1,000 wrappers in banded money. And he then has another $3,200 that he takes, and he goes and clears up his license problems, his insurance problems, and he then registers. So he's got probably not just, the $2,500, he's got close to $5,000 now all of a sudden that he's using to buy the BMW and clear the way to get it registered and insured and put in his name.
Was that information obtained as a result of an investigation of the murder charge, or was it obtained as a result of an investigation into I don't want to be careful what I say here, of unrelated drug charges?
I believe it was the murder investigation because they find the body, then they determined about the BMW, and I'm a little hazy about this. There's a lot. I apologize, Judge. The BMW was evidence in this case. It was used. They used the drug money. All of a sudden, here are these 2, and they've got a lot of money, and which they didn't have before, and now they're buying a BMW. So the BMW itself was evidence, and it was purchased within 24 hours, with the Commonwealth's case, of the victim's death, and it was certainly would be probable cause to believe that it might contain trace evidence, it might contain fruits of the crime, or things that would link these defendants to the crime.
At the time of Juvenile 2's interview, was Vacher a target of the investigation?
He was a target in that he was one of the 3 they were investigating. He was not the sole one. They were not going after the 2. And I think when you read the motion to suppress, the police were looking and focused on all 3 of them. There was none of this.
I'm sorry, all 3 being Juvenile 1,
Juvenile 1,
2.
Juvenile 2, and the defendant, excuse me, Your Honor. And it was not, let's go after the 2 juveniles because we want to get Vacher. Vacher was an equal partner, if you will, and the police considered him to be an equal participant within this. There's no evidence in this case that the police thought, we can get him for murder 1, and he's going away for life without parole, so we're just going to, and we can't do that with these 2 juveniles. There's none of that in this case. The police, when you read that, will see we're investigating this, the involvement of all 3, and it was very methodical from when they found the body to try and trace it back. And Juvenile 1, Juvenile 2, and the defendant are just intertwined in this case.
To the extent that target standing has any viability, does it make any difference that the fish involved are big and little, or if they're all of equal size, does that make any difference to the analysis?
Well, I think target, it has said that you have to find that they are just violating, or these 2 are they're not important enough, and that we're trying to focus on the big one. I think that there is that distinction. So it's not just, I think you have to find that the police were focusing on the bigger fish.
Do you concede that there was a Mavrodakis violation?
I don't read it that way. When you read the juvenile judge's findings, he says the reason why he's suppressing it is because there were statements made when the father, and I don't think that the findings were as egregious as the defendant says. The juvenile judge says, I'm suppressing this because there were statements made while the mother was the interested adult when she first came there. And when you read the statement, the findings of fact, you'll see that the mother was told, you're the interested adult, she was given all the rights, you can consult whenever you want, and they do. And when the aunt, Estrella, the aunt, calls the lawyer, and the lawyer comes in, and the lawyer's card is given to the mother, and the mother says, we want to keep going, I don't want to talk. So it wasn't that the lawyer was kept from the defendant, it's the defendant's mother. Where the judge said it was, well, the police didn't give the card to the defendant himself. They gave it to the mother, and it wasn't the mother's job to make the decision as to whether they stopped or not.
Well, is it your position also that there was no violation of Commonwealth versus a juvenile's requirement for a concerned adult?
What the judge makes the finding is the judge says that the father, who had primary custody, he comes in at a later point. And at that point, the mother leaves, and the juvenile, too, is making a statement. But the father had not been advised that you're the interested adult, you're entitled to make these. And that is the reason why the judge suppresses it. He says the father wasn't given the interested adult.
So the father didn't know what role he
That's what the judge basically says. Well, they didn't stop, and when the father came into the room with the mother and juvenile too, they didn't stop and they didn't say, okay, you're here now, you're the custodial parent, so now we're going to give you the interested adult. And that is basically what the juvenile judge finds. And they say that the statements are made. So it's really, I hesitate to use the word de minimis, but the judge finds even though it's a very minor violation, it is a violation, I agree. And that's the way the judge found, and we're bound by what the judge finds. But he then goes on and says, these statements were all voluntary. This was just, as the motion judge found on all of the motions to suppress from the Superior Court, and I'm talking about the Superior Court judge now, not the juvenile court judge. The Superior Court judge finds that this was a technical, quote-unquote, technical violation of the interested adult, and that the judge found that these statements were all voluntarily made. There was no coercion. There certainly wasn't any overbearing. His will was not overborne. Certainly nothing that the cases that contemplate allowing target standing or suppression allow.
Well, so is your position that when there's a technical violation, it's okay?
No, I'm not saying that, and I don't mean to say that, Your Honor. I apologize. What I mean to say is the judge found that it was, on a scale of 1 to 10, the violation was probably a 1 or a 2. I don't know how else
there was also, I thought the judge also found that the mother had attempted to call an attorney, and that was effectively an invocation of the right to counsel.
Well, they call the attorney, and the attorney comes in, and the card is given to say, he's here, here's his card. And the mother says, we're going to keep going. I don't want to talk to him now. We're going to keep going. But what the judge found is that the card was not offered to the defendant for the defendant to say the same thing. So, and the judge says, well, the defendant should have been given that opportunity.
You're saying that the judge did not say that the discussion should have stopped when she said, I wish to call an attorney?
The way it comes up is she tells the police, and I believe this, I read this last night, she's aware that an attorney has been called and is on the way. But they keep going. And there's no indication that the police overbear their will and say, well, we're going to keep going. The mother is making statements of, we want to get to the bottom of this, I want to deal with this. And when the lawyer comes in, and this is in the judge's findings, when the lawyer comes in, the card is given to the mother, and the mother says, we're going to keep going. So it's not that the police overbear his will in this point.
But it is a constitutional violation.
They find that because the son was not, the juvenile too, was not told himself that it was a violation. And if there are no further questions, I will submit on the brief.
Thank you, Counsel.
Thank you.